Okay, so welcome to today's webinar. My name's Carly Hanson. I'm from Community Legal Centres Queensland, and we're really pleased to be presenting today's session on data governance, a framework for community legal centres. Before we get started, I'd like to acknowledge the traditional owners of the land on which we're holding today's webinar. In Brisbane, they are the Turrbal and the Yagara people. I wish to pay my respect to their elders, past, present and future, and acknowledge the important role that Aboriginal and Torres Strait Islander people continue to play in our society. As today's webinar is being viewed by people throughout Queensland and Australia, and we've got presenters coming to us from Sydney, I'd also like to pay respect to the traditional owners of the land throughout the country and extend a very warm welcome to any First Australians who are joining us today. So today we are very pleased to welcome two lawyers from Clyde & Co, Richard Birkin and Rhys Corbett-Wilkins, who are going to be presenting today's session. So today's session, as I mentioned, is on data governance, and they'll be talking to us about cybersecurity and incident response, and providing an introduction to data and the cyber landscape, discussing data governance, what it is and why it's important for community legal centres and other not-for-profit organisations. And they'll also propose a framework for strong data governance with some best practice tips that you can implement in your centre. So when I hand over to Rhys and Rich in just a moment, I'll let them tell you a little bit more about themselves and about Clyde & Co. But just some quick housekeeping. So today's webinar is being recorded, and we'll have the recording available to download later today or tomorrow for you. The PowerPoints and other materials have been emailed out to everyone who registered yesterday afternoon, and they're also available to download from our website and from the handout section of the GoToWebinar control panel. We'll hold questions to the end so that we have a smooth presentation today, but feel free to type them into the question box as you think of them or as something prompts you to ask your question, and we'll be able to talk through those questions and hand them over to our presenters at the end of the session. Alternatively, if you have a microphone and you want to ask your question verbally, you can press the button that looks like a hand at the end of the session, and I'll be able to unmute you. So I'll now hand over to Rhys and Richard, and I'll come back in to chat to you at the end of the session. So I think we've got Rhys up first. Thanks, Rhys. Take it away.
Great. Thanks, Carly. And thanks, everyone, for making the time to join today this morning. We're hoping to spend about 45 minutes just talking through really our experience in what we're seeing from an incident response perspective, and then share some lessons at the second half of the presentation around data governance more generally at the front end, and how you and your respective organisations can start to uplift your processes to ensure that not only you're complying with best practice, but also that you're protecting data that you hold. We have a fairly certain style when we present. We try not to talk at you and try to give you real world examples that you can take away and share with. But just a little bit about Clyde & Co. So we are a law firm. We are a global law firm based in all the capital cities in Australia. We effectively specialise, our team anyway, specialises in incident response. We set up the practice about 7 years ago, and we day to day help organisations of all shapes and sizes, government agencies, private sector companies, small, medium and very large, and including a lot of entities in the non-for-profit sector. So it's a sector that we're very familiar with, and are glad to say that we've been able to help a lot of those entities through fairly difficult periods. So today we're looking to, as I said, there's really two halves of the presentation. The first half is talking about what is data and the cyber landscape, to try and just frame the discussion. The second half of the presentation will then talk around data governance itself. What is data governance as a concept and in practice, and ultimately a framework and some best practice tips to put data governance frameworks in place. Please, Carly said at the outset, hold your questions until the end, but if you do have questions, please send them throughout so that we can answer those at the end for you. So if we look at in the news over the last couple of months, it's fair to say that there has been a number of incidents that have reached mainstream media. And I think as a general lesson, and something that we've noticed over the last couple of years, is 3 or 4 years ago, cybersecurity, information security, whatever term you want to use to discuss this digital and information risk, was something that people knew about, but weren't comfortable in engaging with. Whereas I think over the last 3 to 4 years and more recently, including this year, I think it's generically a topic and a concept that all organizations are much more comfortable in understanding and addressing. However, that said, there are very clearly still a number of incidents occurring and exposing organizations to having fairly poor practices in place. And so I think over the next couple of years, there will be an increased public expectation and an expectation of regulators and other industry bodies to ensure that data itself is protected. So we want to talk today about what is data, how it's collected, and why it's collected. If we look at your CLCs, and we've done this presentation before for New South Wales, you can see that across your industry and across the CLC network, that there is a very large range of types of information that you collect and that is ultimately created and that is stored and held and managed by the CLC network. You can see that you've got a number of different stakeholders. You've obviously got the donors and the financial supporters, which ensure that the CLCs themselves are able to operate. And you've got very clear obligations with those donors around system security, information security, and the like. And also obligations in terms of how you spend your money to ensure it's in line with funding. And a lot of these, this background context is ultimately what we see informs CLC's position in terms of the maturity around information security and data security. And it's very interesting when an incident happens to see how ultimately CLCs manage that stakeholder group in particular. CLCs, like other entities, will contract and consult with various entities, be they contractors to do work for the CLC's program and mission, or alternatively outsourced service providers that either manage data on behalf of CLCs or hold information on their behalf. And you can think about that in a practical sense in your day-to-day work. Are there any applications that you use? Are there any tools that you use to be able to do your work, be it personnel, HR files, payroll, or be it document storage or document sharing? There are a number of different platforms that you use which data is collected in, but it may not be inside your environment. It's actually held by a third-party contractor. Talking about members of the public, so very clearly CLCs being a frontline service, having members of the public walk through their doors for various reasons dependent on the mission of the CLC. You're obviously collecting information about public members, and in that sense, I suppose they would be seen as your customers. And that's the second slide there, the clients or service users. And you can see here as we go through, you've got volunteers, you've got employees, you've got CLC members, you've got the exec levels, you've got government agencies and other organisations linked to CLCs. So you can see on this slide in one key visualization, there are a number of different entry points. There are a number of different types of data. There are a number of different relationships with individuals and entities that all dictate the data that you hold and that you collect. And the legal framework that sits behind all of those different types of data, for example, employee data versus your customer data, all varies, and there are different obligations and levels and requirements applying to each. So this slide, I'm hoping, will show that, in short, there is an overlapping series of regimes and requirements that sit around data itself. So if we look at the not-for-profit sector, often we assist non-for-profits in incidents. It's all too common that not-for-profit will say, but we're just a charity, why are we targeted, why is this happening to us? We're not a bank, we're not a high priority target. How is it that we're having to address this? And I should say that's not a common, an uncommon thought process that many of our clients go through, including the biggest ASX listed entities as well. And the short point here is that no organization is safe, and it is a fairly obvious statement. But if you look at NASA, which is one of the world's most largest technologically advanced, and the data and the information that they store is very clearly some of the most intricate intellectual property, which has global ramifications. Even NASA itself was hacked last year using a fairly cheap off-the-shelf product on the dark web. So the point there is that all entities are in some respects vulnerable. The question is, what do entities need to do to ensure that they're safe, relevant to that entity's size and their operations? And we'll go through some of that today. If we just talk about data itself and the cyber and privacy landscape, this is a quite helpful map, and it's from our friends at DLA Piper. Happy to acknowledge that. They've got a really good website actually that visualizes the various data protection regimes around the world, and you can see at a snapshot here that by and large the Western world, the US, North America, EU, or at least European countries, some non-EU countries as well, throughout Asia and the Asia Pac region and Australia, there are very heavy regulated industries with quite stringent security laws. And then right on the other side, you've got parts of particularly Africa and the Middle East is where we tend to find there being a fairly lacking regimes, and then across the regions everywhere in between. And I think this is helpful to understand. Perhaps CLCs might look at this and say, well, we only operate in Australia, or we're only concerned about here. This is all something that's outside the realm of our concern. But we flag this because this map, even 3 years ago, 5 years ago, 10 years ago, would have looked very different, and it will continue to look different every year. And what we tend to find is that globally, as different regions come to terms with how they should regulate data and its processing and handling, we tend to find that other countries will look to that as models for best practice and implement those laws. And so we're always keeping one eye on what the rest of the world is doing so that we can understand how it might impact here in Australia. Sort of very high level, if we just talk about some of the key data protection pieces of legislation in the landscape. At its highest, you've got the Privacy Act in the Commonwealth, which is the federal privacy laws. It applies to effectively federal government agencies and private sector entities that turn over more than $3 million. And so for any non-for-profit here that turns over less than $3 million annually in terms of its funding, by its face will be carved out from the Privacy Act. However, there are a number of parts of the Privacy Act which brings non-for-profits within it, notwithstanding the turnover requirements. And that includes the types of information they collect, including, for example, tax file number information. You may also have obligations through your funding arrangements with Commonwealth government agency funders, which either through that arrangement brings you into the Privacy Act or contractually puts you under the same requirements of the Privacy Act. And that's typical of government agencies. They do that for their contractors and their third parties with whom they engage. So the short point there is it's very likely that through your contracts with your funders or just generally you'll be subject to these laws. And these laws are the primary laws which apply to the handling of data throughout the various life stages of data at its collection, at its use phase, and it's ultimately its end of life, deletion and destruction phase. But there is also a part of the Privacy Act which has a notifiable data breach scheme attached to it. It was grafted on about 1.5 years ago. It ultimately requires entities that have an eligible data breach to notify individuals and the regulator of those incidents. And that's typically the space that we operate in. Dropping down, the Spam Act. This is a bit of a forgotten cousin, I think, of when we look at data privacy laws. The Spam Act throughout, I mean, obviously by, when it was enacted in 2003, but that kind of 2005, 2010 period, the Spam Act came into place because there was a lot of calls for businesses and individuals ultimately not to be called or contacted without their consent. And so we saw this with the Do Not Call register as well around that era. And the Spam Act itself was a little bit forgotten over the last 10 years, but actually very recently this year, the regulator that sits behind the Spam Act, ACMA, have actually fined a retailer quite heavily for spamming individuals. So I think it's just to flag that whilst it's probably a little bit of a forgotten cousin, it certainly does exist, and ACMA sits behind it and is fairly active in the space. You've got the My Health Records Act, which is relatively recent. It's only about 8 years since it's been enacted, but this ultimately addresses health records as part of the My Health Record scheme. So to the extent that non-profits collect that information, you may find that you're bound in that, and bearing in mind that there's also a separate notifiable regime in respect of data breaches under that scheme. And then the last piece, and not to be overlooked, is underneath all of this, there's various state and territorial privacy laws, and each are different. They are all, generally speaking, principle-based and tend to mostly emulate what the Privacy Act requirements are. Some are more strict than others. Queensland, New South Wales, Victoria, ACT, for example, tends to be more strict. And as you go around the country, South Australia, WA, Northern Territory, Tasmania, etc., tend to be less strict and have less active regulators that enforce those laws. But just to bear in mind that there are those underlying privacy laws, and you might find, non-profits might find that they're actually caught up in both the Commonwealth and their state or territory regime. So if you just have a really quick look here, the Privacy Act we've talked about, you've got at a high level, it regulates the use and handling of personal information. You've got 13 Australian privacy principles. The regulator is the Privacy Commissioner, or OAIC. As I said, you've got small business exemptions if you don't turn over 3 mil, but often your non-profit sector is carved back in. So we talk about at a very high level how the notifiable data breaches scheme work. These are really the tests that you look at when we're dealing with an incident. The first is, does an organisation have an obligation to investigate and assess an incident? And again, that's just a question of whether or not the Privacy Act applies. And often, even when it doesn't, non-for-profits, in our experience, will tend to want to comply with the scheme as best practice, notwithstanding that it's on a voluntary basis. So what do you need to do if you've had an incident? Well, you need to investigate suspected eligible data breaches. In other words, if you've had a data security incident, however that might arise, if it's somebody inadvertently leaving a laptop or a phone on the back of the bus, or it could be, as simple as an inadvertent sending of an email to the wrong recipients, or it could be as complex as a malicious third party gaining access to your systems into an email environment to conduct phishing or invoice fraud, or ultimately to take data and then post it online. There are a number of different incident types, but that is ultimately your obligation. When do you have to notify individuals? Often non-for-profits tend to, in fairness to them, wanting to do the right thing, want to notify people as soon as possible. But often we see, and it's true for all organisations, we often see that entities want to notify too soon without having anything meaningful to say. So it's often a question of when is the appropriate time to notify. But the answer is as soon as practicable, after you've determined that the incident itself is an eligible data breach. How do you notify? You do so by the ordinary means in which you communicate with individuals, and you also then notify the OAIC through its online portal. And then the last piece there, not to scare anyone, but just to flag that there is a penalty regime under the Privacy Act for non-compliance. So these are the 3 questions that we typically go through when we address an incident. Has there been a data breach? And that's ultimately looking at whether or not there's been unauthorized access to systems or disclosure of data, or if there's loss of a device or data that could lead to unauthorized access or disclosure of that data. Is serious harm likely? And this is the key question that we tend to focus our attention on, which is effectively to understand whether or not there is a risk of data misuse. And then the last piece is, can remedial action be taken to prevent the likely risk of serious harm? And that's a very practical test. What that says is if there's anything that you can do to prevent data misuse, then do that. And ideally, you don't have to notify. So for example, if you can wipe a laptop remotely prior to someone being able to open it. This is a very quick slide just to say that this landscape is consistently changing, and there's been calls fairly recently for the Privacy Act to be bolstered and for the Privacy Commissioner to have increased funding to actually investigate incidents and issue penalties and fines. I'll skip over this one. It's just a flag that this is a space to continue to watch to understand your regulatory risk. So if I just have a couple of minutes talking about, and I've only got a couple of slides left before I hand over to Rich, but if I just talk about very practically, what are the types of incidents that we're seeing on a day-to-day basis? And this is in a snapshot at our day-to-day bill. So the first is ransomware and malware attacks, and that's ultimately a computer virus being infiltrated and being dropped into your systems. It encrypts your data and freezes your network, and ultimately you can't use your systems. And we see, particularly for healthcare organisations and logistical organisations, this is quite a crippling attack, with the interruption exposure and costs being quite significant. So it always pays to have a plan in place for a ransomware attack. And that includes being able to resort to backups and being able to ensure that you have a plan in place should this occur so that you can adequately address it. The second type of event is network interruption, and that's ultimately where, for one reason or another, and it's usually because of a utilities failure or because of a software provider that you rely upon being unavailable, we usually see a network interruption event effectively stopping a business from being able to do business. And the lesson there is to understand what your dependencies are and to be able to work around them in a time of need. The third event that we see is social engineering, and others might use the word phishing or scamming or something like that. It's effectively using emails as a weapon to gain information to commit invoice fraud or to be able to phish their way through networks and jump into other people's organizations by tricking that person into clicking on a link, downloading an attachment or opening a file. So our general message there is to ensure that your employees are aware of these types of events and are able to spot phishing emails so that you do not become target. The fourth is cybercrime, and we use that to frame pure cybercrime where funds are actually taken, stolen or fraudulently obtained. And that ultimately, for the majority of cybercriminal activity, is the end goal. It's always monetizing their malicious activities. The fifth there is data breaches. As you can see, although we are lawyers, you can see that we deal with a very wide range of different incidents, but the data breaches, of course, is part of what we do, and it occurs in a number of different ways, which I've already discussed. Six, physical realm and non-electronic records. We just wanted to pause here and just say to teams that data and cybersecurity, I think people will attribute that to being, computer, online, digitally connected environments. But there is also still information security risk in respect of physical documents. We've seen examples in the last couple of years. For example, the government itself had left classified documents in a cabinet, filing cabinet, which was being sold at a secondhand store. So we see this kind of event happening all the time. And just to bear in mind that there is still a risk around physical documents. The second last incident type is a business interruption incident, and it could occur from any one of these incidents, but really what we're talking about there is what is the cost and the operational disruption impact on your entity, and how do you plan for these types of events and have a workaround to minimize, mitigate, or altogether avoid any interruption exposure to your entity. And the last is supply chain risk. It's simply to say that entities nowadays, more than ever, are interconnected and rely upon each other to do business, and that entities process information on a lot of entities' behalf, and just to recognise that the risk may not be within your network, but indeed outside of your network and sitting with your third-party entities. We just want to go to the next slide very quickly to talk about what an example phishing email looks like. And this is not speaking out of school. This was made publicly available by the ANU. It was a very sophisticated email. It says, "Dear members, year has got away from us, and due to a number of factors, ... Happy New Year. Next year, we look forward to having a meeting with you. Meeting planned to refer to you next." Now, obviously, we can't get feedback right now because we're doing a webinar, but maybe have a look at that and think to yourself, if you receive that from what appears to be your senior, in this case, whoever it was, the Vice Chancellor, would you see this as being a phishing email? And I think the answer is gone are the days of the Nigerian prince scam where you're due to inherit $10 million if you just deposit that $10,000 check in the post box. These are very sophisticated attacks, and in fairness, this was one of the most sophisticated attacks I think we've seen for a little while. So you can have a look at this on the ANU's website. They post this up themselves. But the point here is these are sometimes very difficult to detect. The next one is a ransomware incident. This is a carbon copy of a client's ransomware domain. You can see that their computers are infected and that there was a note that appeared that said effectively you've got 1 day until the price would double, and we've blacked it all out to ensure that we don't identify our clients. But these ransomware amounts nowadays, they're much more targeted attacks, they're much more sophisticated attacks. The ransomware amounts used to be 2 or 3 years ago, 1 or 2 Bitcoins, which then was $6,000, $7,000, $8,000. Nowadays, the ransomware amounts are anywhere between $500,000 and $1 million as a standard matter. So it's to say here that you really do need a plan to be able to respond to ransomware, or potentially fall in that position where you need to consider paying, which should always be treated as a matter of last resort. Last couple of slides. We have pulled together our own data from the last month to show what we're seeing, and it fits in with what we've discussed on the left-hand side there with the pie chart. Business email compromise incidents, which is that social engineering phishing style attack. Ransomware, they make up the majority of our work, and the others by a lesser degree. We're seeing a lot happen in tech and education sectors at the moment, and every industry changes month to month. Down the bottom, which I think is probably a fairly interesting slide from a tracking perspective, you can see there through COVID that when you look at March, when the shutdown first happened, there was a decrease in incidents or claims being made. And we attribute that to latency, not because the number of attacks slowed down, but simply that organizations weren't identifying. And then obviously when the lockdown restrictions began to ease, people went back to work, systems came online, that's when they identified these incidents. So we saw a very sharp increase of matters. It's since come back down to a normal amount then, but it's just to show that these things, these societal impacts do have an impact on these incidents. And the last slide here, and this comes back to my point about supply chain risk. We're currently acting for a number of entities around the world who have been impacted by the Blackboard data breach incident, and it's in the public domain, so we're able to talk about it. But effectively, they're a software provider that sits behind a number of educational and non-for-profit sector industries, and it's ultimately requiring thousands of entities around the world to have to deal with this incident, and ultimately notify their stakeholders, being employees and customers and like, about this. So the point there is to say that even though the non-for-profit sector itself might be able to say that they're fairly robust, always have in mind that your supply chain is the weakest link. Okay, Rich, that's it. Thanks for listening in.
Yeah, thanks very much, Reese, and thanks everybody today for tuning in to the seminar. It's great to be able to chat to you and have such a good turnout. I think a super common question that we get asked by clients is, what can I be doing? As you would have heard from Reese, it all is a bit of doom. We're often a bit of doom and gloom to a certain extent, and we're telling organizations, what happens in our experience when an incident strikes, or what can they do to boost the resilience before. There are a number of different measures you'll see up there on the screen, but what we're going to talk about today is good governance and getting a data governance policy in place. I'll briefly chat about what it is and work through a case study, and then we'll talk through a framework of a data governance policy and what we would normally advise clients when they're pulling that together. So if you want to just move on to the next slide, Reese. So incidents are going to be an inevitability. I think we have to accept that we're now in that world. Good governance is going to go a long way to taking a bite out of that incident when it hits. But it also means that you can take advantage of the opportunities that good data governance presents. So what is it? It's the organisation and implementation of policies and procedures for the effective use and protection of the information that you hold. So it's that process of an organisation involving enterprise-wide policies and procedures and importantly, controls to ensure that that data is monitored, data. And this is an interesting one, and I think we're all probably guilty of this, of hoarding data to a certain extent. So I think organizations understand generally what their processes are for collecting and storing it, but we don't understand what we should be doing with it. And I think that's reflected in the fact that the organizations tend to hoard it. And then there's also a trend in us sending data outside the organization and not adequately planning for how we're going to manage that. If you just want to move to the next slide now, Reese. So it's really important to note that data governance is different from privacy law and cyber risk. And you really need to bake all three of these concepts into the DNA of your organization. So data governance is the processes necessary for that effective information management across the entirety of the company. Then privacy are the laws that are underpinning and governing the appropriate use, collection and storage of that personal information to protect individuals. And then cyber risk is the risk of loss, and Reese has touched on some of those particular incidents or where we might see that coming to the fore due to a failure in an organization's IT systems or other processes. So why is it important? It supports that better decision making and improves operational efficiency. It's protecting the needs of the data stakeholders, both internal and external, and particularly around baking in privacy by design to everything an organization does. It also ensures that the organization is going to adopt common standards, and really what we're trying to do is to get into a point with a data governance policy where we've got those controls and those processes in place, and we have people identified in the organization that are accountable for keeping it on track. And it's also going to just ensure the clarity and transparency around the access and use of the data. So data is an asset that can be leveraged for growth. The security of it is important, and particularly with the legal and regulatory and other implications if things go wrong. Consequently, data governance is starting to appear on a number of the risk registers, and increasingly we're seeing it being discussed at board level, and there's an expectation that boards are starting to take notice and plan for good governance. So proper data governance allows organizations to take full advantages of those opportunities and avoid those risks like we've touched on. So what are the risks? Well, it protects against a range. So you've got missed opportunities, so those commercial drivers, and in the context of community organizations, it's that are often getting donations and funding. So it's that loss of that advantage. You've got reduced efficiency there, particularly as we're collecting more and more data as we become increasingly digitized. You've also got a reputational risk there. If you're having an event or it becomes known to your stakeholders that you've mismanaged data, you've got that loss of trust. It can also change the perception of an organization as safe, particularly regarding donations. Now, the last point there is around legal and regulatory risks. It's an interesting one. We've touched on the privacy aspect to it, but what we're increasingly seeing in the context of the not-for-profit industry is government departments in particular with funding arrangements are almost like night follows day. When they are aware of a data breach, they're issuing a show cause notice to those organizations. And we're finding that in circumstances where the OAIC is, we're still in a relatively soft regulatory environment from that perspective, where we see our not-for-profit clients really encountering difficulties is in engaging in this show cause process and going through that process of convincing their funders that the event has been appropriately handled and managed. So it's definitely something to watch. Just want to briefly touch on a case study, the New South Wales Ambulance Service. A number of you may have heard about it. It's quite an interesting one. A contractor was working for the service as an injury management coordinator. New South Wales Ambulance didn't have appropriate controls in place in their IT system, which allowed this contractor unfettered access to various databases. That contractor accessed the data of employees and then on-sold that information to what was thought to be a group of personal injury lawyers. The irony's not lost, but sold them the data so the lawyers could ambulance chase the ambulance staff. So in one of the first actions of its type, there was a class action filed on behalf of these employees, and recently they've handed down award of compensation for 108 employees affected by that incident, and each receiving compensation in a range of $2,500 to $10,000. Significant because we haven't really seen an award of damages for misuse of data like that. Question mark whether appropriate data governance policies or procedures would have prevented that contractor from accessing that information, but it's definitely an interesting case study. So again, it's not all about the risks and the bad news stories. Data governance provides a range of opportunities to the organisation, monetization of data, less significant for not-for-profits, but what is really important is that improved stakeholder loyalty and programs to get those donors much more loyal to the organisation and get into that regular course of giving. You're able to improve internally systems. It's good for your reputation, and like Reece had touched on, organisations can really die in the ditch in terms of how they handle an incident. So having those good procedures in place and quickly and effectively managing an incident can really help. You're also going to just see general efficiencies as you streamline operations, and particularly, like I touched on before, putting those procedures in place around the data retention and how much you're hoarding and hanging on to can also achieve a range of efficiencies and cost savings for an organisation. So with that said, just want to briefly run through a framework. Now, like I said, this is probably, on the next slide, is probably the framework that we roll out for data governance policies for an organisation. So this is going to entirely vary from organisation to organisation. It's wholly going to be dependent on your size and resources. But what we would say is, if you can take away this framework today and start thinking about that, together a working group, if you haven't started yet, then it can be really beneficial to the organisation, even just to have had a session where you're starting to plan this out if you're not quite in that space yet to develop a policy. So just moving on, these are the buckets, and this is how a data governance policy would usually be structured. Have a think about pulling this together, like I said, or dust off the existing policy and review it against this framework. So we're first, the most important step is to identify your data, to map that out, to understand who is collecting what in your organisation and where does that data live. Second, you're going to identify stakeholders. And that's part of the data mapping process, just understanding where does that data flow once it's in the organisation, who's responsible, and what controls are in place depending on the sensitivity of that data that keep it safe. And once you've done that, you're in a position to establish a policy and then establish a process of regular review. It is really important to actively monitor it, and we would suggest that at least once a year, you're reviewing that policy once it's in place to make sure that it's still meeting the current needs. We know that this space moves very rapidly, so it can't be a static document. It also can't be a 90-page novel. So it's about what are these quick, easy wins, making it really easy to read, easy for staff to follow, and making those roles and responsibilities clearly defined. And then overarching enterprise strategy. So that's about starting to understand how data governance fits into the overall framework alongside your privacy measures and managing and responding to cyber risk. So that first step, I'm doing a bit of a deeper dive there. This is an example that's been pulled from a policy, and this is a really important step. I don't think for any organisation they need to go through this process. It's too costly and unwieldy to deal with information, large amounts of sensitive and protected information. So it's about during that data mapping and data identification process, it's about understanding what's our sensitive data we hold, data about employees, for example, what's the information that is not so sensitive, and then designing a process to fit into that. So then next, you'll identify stakeholders and assign roles. So you've got a data governance council or a governance board. This can be a few staff members starting to get that discussion going around data governance and put in place that policy. They're overall responsible for the policy. Then you've got the data manager or data owner. So to control that data for the organization and ensure its protection. So that's usually one of the senior management. And then you've got a data steward who contributes to that business expertise and maximizes the value and really drives those benefits. Then you've got a custodian, their role to protect and secure that. So that's usually IT. And then you've got the user, and that can be the workers in the business that are collecting or handling or using that information. So in developing your framework, it's really important to clearly establish those goals and purpose. Like I said, the goal here is not to develop an overly complex novel that's difficult to follow, that you're not going to get any active engagement with from the various stakeholders in the business. Only implement governance where it's needed, and make sure that you're selecting those champions in the organization that are going to be able to really drive that forward and take some responsibility. Keep it simple and pragmatic. It really is, when you strip it back, quite simple building blocks, and so it's important to align it with that. Design it from the top down, but then implement from the bottom up. And this is, it's about getting business buy-in. Be flexible. There's going to be no one size fits all. In our experience, just given an organization's data practices, there's going to be a transition period. So we would recommend, if you haven't got those policies in place already, that you then also implement a remediation plan to make sure that there's a period of transition there while the organization is upping its standards there. And then provide a clear communication. What we do is we'll often develop a 10-page policy or less that is identifying all of the framework and setting that out like we've discussed. And then we'll do a 1 or 2 page really visual flyer that can then go out to all staff that has the basics around the expectations of them. I find that's a really good way to socialize the policy with the wider organization. And that's what we're just saying here. Make sure that we've got that really easy cheat sheet for employees, so they know what their roles and responsibilities are at all levels, whether that be those that are sitting on the data governance board or the end employee that's collecting it and using that information. So just circling back on top tips, and we'll stop for some questions after this, but data governance it's broader than privacy or cyber risk. So like we've discussed, it's about really baking all 3 of those concepts into your planning and starting to address this in a coordinated way. Think about it as an opportunity for your organization to drive those efficiencies and take the bite out of an incident when it hits, and then if in doubt, seek that assistance around the planning process just to make sure that you're on the right track. But for those organizations that haven't considered governance at all, it's as simple as forming a working group and just getting that discussion going around what data do we hold, what's our process, what's the life cycle in the business, and how can we put more of a structure around how it's managed and controlled. So that brings us to questions. If people want to type those in or raise your hand to leave an audio question.
Thank you so much, Rich and Reese, earlier in the session. Look, I thought that was a really useful and practical exercise, and really like the idea of a 1 or 2 page cheat sheet to put on the wall for all of your staff, because I think it's really easy to get down in the weeds of data and privacy risk, and that can be a bit overwhelming for your general staff. team who might not sort of be au fait with some of the various complex terms and legislative requirements. So we'll turn to questions now. So just a reminder that you can type those questions if you've got them while we've got our expert data and privacy lawyers in the room, in the virtual room, I should say. Type those into the question box on the GoToPanel box on your screen, or raise your hand and we can unmute you to ask your question. So Rich and Reese, I have got a question that came through earlier. I'm not sure whether this is outside of the scope of what you've been discussing today, but hopefully you might be able to assist. So just a question around whether Australian NGOs would need to comply or will be impacted by the EU General Data Protection Regulation. Are you able to talk on that at all?
Yeah, happy to. I might jump in, Rich, if you want to jump in afterwards.
Yep, good.
So GDPR came into force last May, and I think when it first came in, probably unlike the Australian experience earlier that year, the world, but particularly obviously EU countries and anyone that does business with the EU and anyone that is a part of a global organisation with a country in the EU, quite rightly was very concerned, and probably because of the large penalties attached and associated with that regime, and the sense that that the regulators in the data protection authorities in each of the EU jurisdictions were probably quite active, or at least compared to other countries, including Australia at the time. So there's this big rush at the time to comply with the GDPR and ensure that organisations understood where they stand. There's a number of legal tests that go through ultimately whether or not an Australian NGO is subject to the EU, and in a very practical sense, it's effectively you need to be established there, and that is either because you're incorporated or you have assets or people in that entity. But where we typically have this question and where it's a grey area is where you're not established, you don't have that asset or that incorporation in that in those jurisdictions. And typically we see this where you're collecting data about EU residents in some shape or form. So for the most part, we tend to find that purely Australian domiciled customers that don't do work or don't provide services to, or ultimately collect data about EU residents, tend to not be caught up by it. But what is interesting as a pragmatic perspective is public expectation now has shifted because of the regime, such as the GDPR, where you've got 72-hour notification obligations for data breaches to the at least to the Data Protection Authority in the first instance, and then certainly to affected individuals fairly quickly thereafter. There's this public expectation that data breaches are notified very quickly after they first are identified, and so you have this competing tension whereby in Australia you have notionally 30 days against other regimes, and that goes back to my slide where I showed you the kind of the map of the world and the different jurisdictions. So you do find that notwithstanding the legal arguments that you could make around it not applying at all, or you know, to the extent that it does apply, there's even legal arguments that you could, you know, suggest that you don't have to notify immediately. Notwithstanding those legal arguments, there is this public expectation that you are taking these incidents seriously and that you're responding very quickly. So it's an interesting question, one we hear all the time. The other question we also hear is, if we had to choose one regime globally, which one do we choose to ensure that we have best practice? And that's particularly for entities that are subject to a number of different regimes. And the answer is, unfortunately, you can't just pick one and take that as to be compliant with all. But generally, because each of them obviously have their own nuanced requirements from a data handling perspective, but also from an investigation notification perspective. And of course, then there's different penalties that apply, and the regulators are active and or more or less active in each jurisdiction. So we do tend to say to organisations that if they do want to pick one, certainly you could look at something like the GDPR as a fairly high watermark, but then bearing in mind that that comes with costs and that comes with obligations, which may ultimately be restrictive on organisations. So you really do have to understand, you know, what is the pure legal requirements, and then where do you want to sit around that from a cultural perspective? How do you want to pitch your business and your organisation against those requirements? Do you want to be seen as doing best practice, notwithstanding voluntary? Or are you happy to say that, you know, you want to do what's right, but ultimately being in the non-profit space, we have to allocate resources appropriately. So there really is that tension, and I think that's the kind of the first comment that I made at the outset with with the non-for-profit is there really is that genuine tension where everybody is trying to do the best and ensure that they're doing the right thing, but you've got very onerous and restrictive funding obligations, and are only allowed to spend certain amounts on certain things in line with those requirements. Yet at the same time, you've got high expectations because you've got government funders typically who either through their contracts or their expectations will pass through very high obligations to you. So we do feel for that sector, and that's why we see a lot of our work is aimed at trying to educate and assist that sector because of these competing tensions. But yeah, it's a very long way of answering the question, but the answer is very likely not, unless you're doing business with Europeans.
Just chipping in there, that Blackboard example that Reese mentioned, we've got not-for-profit clients who collect donations from individuals in 100+ countries around the world who are now impacted. It does get to a point from a resource perspective where it would be too onerous to go through all 122 countries to identify that. Now, some clients want to go through that process, some don't. So we try and pivot the discussion slightly around what is the risk posed to those individuals, what's that likely harm that could flow from it, and we deal with it in that way. So we ensure that we're getting to those impacted individuals, notwithstanding what frameworks might be in place there, to give them those recommendations around what steps they can take to protect themselves.
That's great. Thank you so much for such a comprehensive response. And the person who asked that question comes from a national organisation, so there is potential that they are sort of dealing with players who are outside of Australia. So hopefully that was helpful, Joe. Another question's come through from Rachel. So Rachel says, you discussed the different levels of data regulation in each country. Does this only refer to criminal regulation? Because the US has high regulation, but they have a lot of potential access through, for example, the Patriot Act. So I guess the question is, do these protection levels also apply to different types of law other than criminal?
If I can rephrase the question. So sorry, is the question, are we trying to understand the applicability of the US laws, or is it more to say that do we have criminal components in our Australian laws similar to what's in the US? Is that the question? Sorry,
yeah, I'd say it would be the Australian. Rachel, if you want to clarify if you're still there, but I think it would be about the Australian jurisdiction. Yes.
So if I can take the assumption that are there kind of criminal elements to this in Australia. So it's interesting. I mean, when we deal with the data privacy space, we're typically talking about privacy laws, data protection laws, and the like, be it in a health space or a personal information space or whatever it might be. But obviously there is there are obviously state and Commonwealth under the federal scheme, crimes laws that apply to computer offences and data misuse offences, and so we do see that more often than not arising in the space of pure financial crime. So if, for example, you've got business email compromise incidents where typically the anatomy of that attack is somebody gains unauthorized access or hacked into somebody's email account and then issues invoices to third-party suppliers with a view that they misdirect funds from the intended recipient to the bank account, and then behind that activity there'll be a mule that would have set up a legitimate bank account, and they get paid to do so. And typically it's overseas students or vulnerable individuals that actually don't realise that they're participating in criminal enterprise. They actually are told to believe that they're helping a charity set up bank accounts in Australia, so they're none the wiser. And then you've obviously got those that then collect the cash out of the account. And so in Australia, over the last couple of years, you've had the New South Wales Police in particular, but other state and federal, the AFP including law enforcement bodies, starting to become really active in this space and starting to arrest those individuals in that criminal supply chain. There's that aspect, and there's a number of instances where people have actually taken data either for their own gain or for the purpose of misuse, and have been arrested. And there's a couple of high-profile ones that we've worked on. If you kind of Google through the last couple of years, you'll see a property development company last year, and then a tech company the year before that, where you've had some pretty high-profile scalps. So if I understood the question correctly, are there kind of criminal aspects to this and data misuse? There are. But in the US, it's interesting. In the US, in some respects, they're much more advanced in their thinking around this, but then in a lot of respects, they're not either, and that's purely because they are, like Australia, obviously they're much more driven by their states having their own way of doing things, whereas at least in Australia, being federated, we have a bit more of a consensus around this.
Okay, Rachel, hopefully that answers your question. No other. Sorry, Rich.
I'll just fit in there. I think even stepping back from just considering it as criminal, I mean, you've got privacy obligations, but you've got to also consider there's a range of different other legislation and other competing considerations. So we try and approach it from that more holistic angle. It's not just privacy. Something that's quite interesting and will be quite relevant to a number of the organizations is you've got this competing tension where, say, we've seen it arise a lot in, say, in the context of domestic violence support services, where on one hand, there's an obligation to notify individuals about an event, a data disclosure event, arguably, but then on the other, there's these duties of confidentiality, and then it raises the act of notification itself to deal with what might be a residual risk of that information ever getting in the public domain is competing and creating real safety issues, or at least the perception with that individual that they're at risk. My one remark would be that although there is a privacy framework there, it's important to consider the other factors at play, and that might sometimes drive a different outcome, and it's something to weigh up. So you can't just approach privacy in a cold manner like that and apply those rules without also considering the other forces at play in your particular organization.
That's really interesting and very relevant for our sector, who do a lot of work in the DV space. So certainly a good note to really think about the context of your organisation and the work that you do in light of the privacy and confidentiality obligations that you have as lawyers, and also under the Privacy Act and other acts. So that's all the questions that have come through. Obviously, Rich and Reese, you have just covered the field, and everyone's totally on top of their privacy and data governance stuff now, which is awesome to know. Were there any final remarks that you wanted to make before we finish up today's session?
Probably one last remark is just to, mirror back and say thanks for the opportunity, but also to the good work that the CLCs do. I mean, as I said before, that you're the front line, and we hold that to be so, and very grateful for the opportunity to present. One space that I think, and to the last comments that we were just talking there, is around DV is also, I think, as a growing trend going forward, is this space around, I hate the term, but, revenge porn or misuse of, photos and the like, and particularly for our younger generation, I think that's definitely a space that that we all need to work on in terms of educating youth around, the long tail nature of data misuse and how it might affect them for their life. So I know there's probably a couple of CLC networks that deal with that space with young kids. So yeah, take my hats off to all of you. Thank you.
Thank you so much.
Thanks very much for the opportunity and for those questions at the end. And we're very happy to present and share our thoughts and our experience in this space. Feel free to flick Carly any questions if something comes up, and we're happy to prep a response and get that back to you over email.
Fantastic. Thank you so much for that, Rich. I'm sure people will absolutely love to take up that opportunity as they start delving into their data governance. And thank you both so much for your time this morning and sharing your expertise. I think, this is something that we take very seriously in CLC land, and, potentially we'll keep sort of revisiting these issues over the next few years and watching the space very closely. So again, thanks everyone for joining us today and for your questions and your attendance. When we finish this webinar, you'll see a quick survey will come up. So we'd appreciate your thoughts on how the session was today and where we might take this topic next. But I might now finish up the session, and hopefully everyone has a lovely day and We'll see you next time for our next webinar. Thanks very much.
Thanks all.